an appeal by the government of Malaysia against the decision of the Court of Appeal, which held that the words offensive and annoy, the unpunched words within the section 233, subsection 1, para A of the Communications and Multimedia Act 1998 are unconstitutional and struck them down. On 13 November 2025, this court has granted leave in respect of the following question of law. Question 1. What is the effect of Article 4, Clause 2 of our very Constitution in the circumstances of this case? 2. In the light of the strike position, that is, certain provision of the law construed in one way would make them consistent with the Constitution, and another interpretation would render them unconstitutional. The court would lean in favour of the former construction. Whether the interpretive approach unicated by the English House of Lords in Deputy Public Prosecutor against Collins and other subsequent decisions pertaining to the Section 127, subsection 1 of the United Kingdom's Communication Act 2003, Sections 1, subsection 1 and Section 1, subsection 4 of the United Kingdom's Malicious Communication Act 1988 and Article 10 of the European Convention of Human Rights has relevance in interpreting Section 233, subsection 1 of our CMA and Article 10 of our Federal Constitution, considering the striking similar equivalent provisions found in the respective legislation. Question 3. Whether the object of the Section 233, subsection 1, para A of our Communication Multimedia Act, including the words offensive and annoy therein, is to prevent the misuse of public electronic communications network and to protect the basic standards of our society. Thus, it is the interest of the public order and morality under Article 10, Clause 2 of our Federal Constitution. In the light of question posed, several issues will be discussed. How is Article 10 of the Federal Constitution to be interpreted and constructed in light of Article 4, Clause 1 and Article 4, Clause 2? How is Article 10, Clause 1, para A of the Federal Constitution to be interpreted and constructed? What is the meaning of freedom of speech and expression? Whether the impugned words in Section 233, subsection 1, para A of the Communication Multimedia Act 1988 are unconstitutional. Whether the impugned words in Section 233, subsection 1, para A of the Communication Multimedia Act 1988 as falls outside the permissible restriction provided under Article 10, Clause 2, para A of the Federal Constitution.
My Lord, I'm Putri Raihan, Senior Federal Counsel representing the Government of Malaysia. Our line of argument is as follows. The original intent of Article 4, Clause 2, Paragraph B of the Federal Constitution is to immunize both questions of whether a restriction relates to a permissible ground under Article 10, Clause 2 of the Federal Constitution and whether the restriction is reasonable in circumstances from judicial scrutiny. We submit the historical records comprising minutes and reports of the Federation of Malaya Constitutional Commission and Working Party. The documents will show the original intent of the framers underlying Article 4, Clause 2 of the Federal Constitution was that it expressly immunized laws made by Parliament under Article 9, Clause 2 and Article 10, Clause 2 of the Federal Constitution, which are in derogation of the rights set out in Article 9, Clause 1 and Article 10, Clause 1 of the Federal Constitution. A note of dissent from the Red Commission by Mr. Justice Abdul Hamid suggested that any restriction imposed by the legislature should not be challengeable on the ground that the restriction is not reasonable and that the legislature alone should be the judge of what is reasonable under the circumstances. Therefore, in light of the minutes and reports of the Federation of Malaya Constitutional Commission and the Working Party, the decision of the Supreme Court in Public Prosecutor against Tung Chan Chun should be revisited.
My Lord, representing the respondent HEIDY QUAH GAIK is Muhammad Aizat Haikal bin Ahmad. With respect to the appellant, the interpretation proposed by the learned appellant is not consonant with the express and underlying purpose of and spirit of the Federal Constitution, which embodies the doctrine of constitutional supremacy. As the Constitution reigns supreme, any specific restriction in the fundamental liberties which are expressly conferred in Part 2 of the Federal Constitution should only be interpreted so as to limit the particular liberty strictly to the extent provided. That, in turn, means that while Parliament intent or judgment in respect of the specific restriction relating to the national interests are not to be challenged in terms of the judgment or intent of Parliament, the legislation in question can still be questioned in relation to whether it falls within the purview of the permitted restriction stipulated under Article 10, Clause 2, Para A of the Federal Constitution. short, the limitation in Article 4, Clause 2 of the Federal Constitution ought not to be construed as to nullify a fundamental liberty expressly conferred by the Federal Constitution, as this would contravene the doctrine of constitutional supremacy. This is strengthened by the public prosecutor against Pung Cheng Chon, where it is said that a law which purports to have been passed under Clause 2 is open to challenge on the ground that it is not in any of the interests set out in the clause, since any other, more extensive meaning to be assigned in Article 4, Clause 2, Para B would render Article 10, Clause 2 odious. Moreover, the court should not easily depart from good law.
My Lord, I shall now deal with the second issue, a scrutiny of Article 10, Clause 1, Paragraph A and Article 10, Clause 2, Paragraph A of the Federal Constitution disclose that the matters in respect of which the Constitution lays restrictions are matters relating to the interests of the security of the nation, friendly relations with other countries, public order or morality, restrictions to protect privilege of parliament or any legislative assembly, or to provide against contempt of court, defamation or incitement to any offence, whereby these restrictions relate to matters in respect of which parliament is best qualified to determine in the interest of the nation. These restrictions do not infringe the fundamental liberty of individuals to express their views or opinions freely and robustly in respect of the system of democracy practiced by the nation, nor restrict their views and opinions on matters in general within the nation. Therefore, Article 10, Clause 2, Paragraph A of the Federal Constitution merely defines the restrictions but does not define what amounts to freedom of speech in Article 10, Clause 1, Paragraph A of the Federal Constitution. It cannot be inferred from these restrictions that all other speech and expression fall within the ambit of freedom of speech and expression in Article 10, Clause 1, Paragraph A of the Federal Constitution. Drawing inspiration from other jurisdiction case law, the Constitutional Court of South Africa in Islamic Unity Convention, an independent broadcasting authority, and others held that the core of the right to freedom of expression is the freedom to receive or impart information or ideas, and that the free exchange of ideas in an open and democratic society serves an important public interest. It was held that the pluralism and broad-mindedness that is central to an open and democratic society can be undermined by speech, which seriously threatens democratic pluralism itself. In Section 233, subsection 1A of the CMA included the words abuse, threaten or harass in relation to the impugned words, because a consideration of the section in its entirely reveals that communication which is offensive may also be coupled with intent to annoy, abuse, threaten or harass. So the right to freedom of speech and expression under Article 10, Clause 1, Paragraph A of the Federal Constitution does not protect speech that amounts to advocacy or hatred on the basis of race or religion and which amount to incitement to cause harm. The regulation of these types of speech will not interfere with Article 10, Clause 1, Paragraph A of the Federal Constitution.
My Lord, we contend that the concept of inherent restriction within freedom of speech is one that is primarily found in the legal discourse in the United States, and that such restriction should not be read into the right of freedom of speech and expression in Article 10, Clause 1, Para A of the Federal Constitution. The default rule should be that all speech is protected under Article 10, Clause 1, Para A of the Federal Constitution, and it is for the legislature to show that any form of restriction is to be pigeonholed into one of the permissible head of the restriction under Article 10, Clause 2, Para A of the Federal Constitution. Thus, there is an assumption to be read into Article 10, Clause 1, Para A, that all speech, including hate speech and speech which offend religious sensitivities, comprise protected speech.
My Lord, the approach suggested by the respondent, namely that all speech fall within Article 10, Clause 1, Paragraph A of Federal Constitution is, with respect, untenable freedom of speech in itself is not absolute, meaning that there are inherent restrictions when interpreting and constructing that liberty. Therefore, to construe Article 10, Clause 1, Paragraph A and Article 10, Clause 2, Paragraph A such that there is no recognition of this principle is not, with respect, a reasonable approach to adopt. No Malaysian cases have had the courts precluded adopting an approach which gives consideration to what amounts to free speech, gives it inherent limitation. It is the judges in each case, such as public prosecutor against Azmi Sharum and Sepakat, Effective Sendirian Berhad and Menteri Dalam Negeri and another appeal will determine whether the impugned words or phrases fall within or outside the freedom of speech. My Lord, continuing with the third issue, in interpreting and construing legislation like the CMA, the entirety of the impugned provision has to be looked at and considered holistically in terms of both the section and the Act as a whole to determine the intention of Parliament in enacting the provision. This is evident from Section 17A of the Interpretation Act. The object of CMA is stated in Section 3 of the CMA itself, which may be summarized to instill or to promote the spirit of non-intrusion into the sphere of freedom of speech and expression. Furthermore, the intent of the Act may be construed from Section 3, subsection 3, which provided that nothing within the CMA shall be construed as permitting the censorship of the Internet. Thus, the intent is not to allow censorship. The mischief targeted by Section 233, subsection 1A of the CMA is to prohibit such communication, which in any event does not fall within the purview of Article 10, Clause 1, Paragraph A of the Federal Constitution. It does not seek to prevent or preclude free speech and expression, neither was it enacted to encroach on the fundamental liberty afforded there. When the purpose and object of Section 233, subsection 1A of the CMA is to preserve and protect Article 10, Clause 1, Paragraph A of the Federal Constitution, which itself does not protect communication undertaken with intent to annoy so as to cause harm or injury, it cannot then be said to violative of that very liberty. That be all. Thank you.
My Lord, we will argue that Section 233, subsection 1, para A of the Communication and Multimedia Act does enroach into the freedom of speech and expression as provided for in Article 10, Clause 1, para A of the Federal Constitution, because the words used there are broad and vague. More specifically, the two words offensive we intend to annoy. It is vague in the sense that it is subjective and variable and may therefore interfere with freedom of speech and expression. This may well result in incorrect or unfair prosecution, as was the case with my client, HEIDY QUAH here.
My Lord, with regards to the fourth issue, there are several permissible restrictions outlined in Article 10, Clause 2, Paragraph A of the Federal Constitution. In the instant case, the relevant restriction is in the interest of public order or morality. The term public order must be evaluated in the context of the digital age as seen when the Federal Court in Dharma Surya bin Risman Saleh and Menteri Dalam Negeri Malaysia and others define public order in the context of preventive detention law. We assert that public order refers to the general security and stability of society and communities ensured by compliance with laws and the ultimate purpose of protecting the physical and moral integrity of the communities, individuals, and their property. Public order in the digital age, however, is not confined to the traditional understanding of the phrase as it applies in the physical world. Disruptive, demeaning, or derogatory communications in relation to race or religion intended primarily to cause distress, anger, or harm in the online world can lead to grave repercussions in the physical world. Such communications would fall within the purview of a communication which is offensive with intent to annoy or abuse. It would not immediately fall within the other words in Section 233, subsection 1, Paragraph A of the CMA, namely obscene, indecent, false, or menacing. This goes to show that the absence of the impugn words may well leave a vacuum in respect of such disruptive and even dangerous communication by use of the network facilities. For these reasons, even if it is considered that the impugn words in the CMA infringe Article 10, Clause 1, Paragraph A of the Federal Constitution, it allows in the particular circumstances prevailing in our jurisdiction that those words read in totality within Section 233, subsection 1, Paragraph A of the CMA comprise a permissible restriction under Article 10, Clause 2, Paragraph A of the Federal Constitution and are therefore not inconsistent with the Federal Constitution. The impugn words should not therefore have been struck out under Article 4, Clause 1 of the Federal Constitution.
My Lord, protection of public order has been used to justify criminalization of speech that is obscene, indecent, false, or menacing in character with intent to abuse, threaten, or harass another person or even to incite violence. We had no quibble about that. What is at stake is offensive speech that is made with the intention to annoy, which we submitted would not be a permissible restriction on ground of public order. In the context of Article 10, Clause 2, Para A of the Federal Constitution, public order means speech or conduct which would consume a whole community, causing them to take to the street, igniting a mass protest that disrupt even the kill of life and disrupt the proper ordering of society as a whole. We would underline the fact that there is nothing in Section 233 of the Communication and Multimedia Act that suggests that offensive or annoying is aimed at preserving public order. In fact, Section 233 of the CAA makes no distinction if the communication is made to a person or a group of persons. Further, disruption to public order is not an element of an offence under Section 233 of the CAA, unlike other statutes. For example, Section 504 of the Penal Code and Section 14 of the Minor Offences Act 1955, where a breach of peace is expressly stated. Compared to Section 233 of the CMA, there are no nexus between public order and the impugned word. While civility of discourse over the internet would be ideal, the lack of it is not inimical nor injurious to society, justifying the policing of offensive speech with the intent to annoy. There are already a host of offences created in criminalizing communication which are obscene, indecent, false, menacing with the intent to abuse, threaten, or harass another, for this may reasonably affect public order if not contained. To venture outside the ground recognized under Article 10, Clause 2, Para A of the Federal Constitution to regulate and restrain speech would not be a legitimate aim. It would have a chilling effect on free speech, which in democratic society appreciate as the cornerstone of all fundamental liberties. Absent that freedom, all other human rights would be at risk. We therefore submitted that Section 233 of the Communication and Multimedia Act would fall outside the restriction in Article 10, Clause 2, Para A of the Federal Constitution. That will be all. Thank you, my lord.
We can deal with the issue one by one before turning to the leave questions. Article 10, Clause 1, Para A, and Article 10, Clause 2, Para A of the Federal Constitution provide the answer as to how Article 4, Clause 2 and Article 10, Clause 2, Para A are to be read and applied. When an unplunged legislation under Article 10 is to be struck out, and Article 4, Clause 2 limits the court's ability to question or challenge the Parliament intention or judgment that the restriction was necessary or expedited for the specific grounds set out in the Article 10, Clause 2, Para A. The legislation in question can still be questioned in relation to whether it falls within the preview of the permitted restrictions stipulated under Article 10, Clause 2, Para A of our Federal Constitution. For the second issue, the liberty afforded under the article is not unlimited license and subject to inherited restrictions, even in the absence of written laws. Article 10, Clause 1 and Para A itself inherently governs the restriction on the rights to freedom of speech and expression. Protected speech are such expressions that further dialogue, expression or opinions or dissemination of information in a democratic society. Any speech which does not conform to content of Article 10, Clause 1, Para A would fall outside the protective parameters of free speech and may be restricted only to the permissible restriction on the right to the freedom of speech and expression as set out in Article 10, Clause 2, Para A. Expressions which cause or inflict injury or intend to incite any immediate breach of peace does not constitute speech as envisioned under the freedom of speech, and expressions as such expressions do not fall within the purview of the fundamental right. The third issue, the mischief targeted by Section 233, Subsection 1, Para A of the Communication and Multimedia Act 1988 is to prohibit a speech or communication which has as its primary purpose the intention to cause harm, injury or distress, which clearly does not fall within the purview of Article 10, Clause 1, Para A of the Federal Constitution. If the word offensive is deleted, communication that is offensive with the intent to abuse, threaten or harass will be deleted. The deletion of the offensive will in effect remove the preview of Communication Multimedia Act. Thus, the Section 233, Subsection A, Para A of the subsection of the Communication Multimedia Act 1988 does not seek to prevent or preclude whether it be free speech or expression, and thus cannot be said to intrude or violate Article 10, Clause 1, Para A of our Federal Constitution. The fourth issue, Section 233, Subsection 1, Para A of the Communication Multimedia Act 1988 is enacted as an alternative to overcome the abuse of freedom of speech and expression, whereby the reason for their instantaneous transmission may trigger retaliatory communal violence. The absence of the impunged word may leave a vacuum in respect of such destructive and even dangerous communication by use of network facilities. When read in totality, Section 233, Subsection 1, Para A of the Communication Multimedia Act 1988 comprise a permissible restriction under Article 10, Clause 2, Para A, and are therefore not inconsistent with the Constitution. We now turn to the questions of law before us. This court answers to the second question, is the constitutionality of the impunged words in Section 233, Subsection 1, Para A of the Communication Multimedia Act is to be determined with reference to the provisions of the Federal Constitution and the effect of those provisions. The English case referred to in question, although most useful were not necessary. In light of our proceeding analysis to this judgment, we decline to answer the questions. We answer the question in affirmative for the third question. We are enormously view the words offensive and annoyed in section 233, subsection 1, para A of the Communication and Multimedia Act are not unconstitutional in that A, the unpunched word do not contravene for Article 10, Clause 1, para A of the Federal Constitution, and further alternative, the unpunched words fall within the preview of a permitted restriction under Article 10, Clause 2, para A of the Federal Constitution. We are also of the view that prosecution against the respondent was unjustified and ought not to be commenced as per the Facebook post, did not fall within the ambit of the section 233, subsection 1, para A of the Communication Multimedia Act. The post uploaded was not offensive as it is addressed a matter of fact and opinion. Since this appeal concerns a matter of public interest, we make no order as to the cause.